Well, welcome everyone again. My name is Verdine van Daarhoven. I'm from the labor team within Briddge, and Esme already explained a little bit what we do. And we will be discussing various subjects today. This is an overview of the subjects we will be discussing. So I would like to start off with the terms and conditions of the employment relationship. And what is an employment agreement? So an employment agreement is a relationship between an employer and an employee. And there are three parts it has to consist of. One is that the employee or the individual actually performs work for the company. The second is that the employee, the individual, receives a remuneration for it. That can be salary, but it could also, for example, just be housing costs, or it doesn't have to be money. And the third one is that it is a very important point is that the individual is under authority of the company. So the company can actually give directions to the employee what the employee is supposed to do. The third point is very important because if you lack that third point, it would rather be a contractor's agreement. So someone, a more individual person who performs work for the company, does also receive reimbursement for it, but has more is not under that authority. So that is a very important difference. And there are lots of different types of employment agreements. You have a 0-hour contract or a min-max contract that an employee works minimum of 10 hours, maximum of 40 hours. But for this seminar, because we have to keep it in a nutshell, we only focus on the employment agreement, just like a full-time employee, 40 hours, 36 hours, 32 hours. And an employment relationship is regulated by various legislation, for example. That is the most important one. Most of the important legislation is regulated in Book 7 of the Code of Conduct. But there are lots of other acts that need to be taken into consideration, like Minimum Wage Act, Working Conditions Act. So please keep in mind that the different regulations can be found in different acts. We won't go through all of them at this moment, but it is important to know that you have to look at a broader scope than just Book 7. Then a collective labor agreement, if applicable, could also regulate the terms and conditions of an employment agreement. We will go into a collective labor agreement a little bit further on, but keep that in mind that legislation rules everything. Then collective labor agreement could rule certain terms and conditions because the legislation in some situations gives the collective labor agreement a possibility to deviate from the legislation. So if a CLA is applicable, also look at the CLA. And then the third one is that some terms and conditions can be agreed upon between the employee and the employer, and have them agreed upon in the employment agreement. So the height of the salary, for example, is an important one if someone is getting a car benefit or commute costs. So there are certain things that you're free to decide on what to give the employee, but always check that it's not in conflict with legislation or, if applicable, a CLA. Another important thing is that if you have a bigger company, more employees, that the employees are provided with the same terms and conditions. And of course, not everyone has to get the same salary, but it's not possible to give someone 30 vacation days and someone 12. So there needs to be equal treatment in the broad sense of the terms and conditions. So collective labor agreement, we could spend an entire seminar on a collective labor agreement. We're not going to do that, but I do want to highlight what it is. So a collective labor agreement is an agreement concluded sometimes between a company, but most often by an employer's organization and an employee's organization or a union. And those two parties discuss and agree upon an overall collective labor agreement that covers an entire sector, market sector. For example, if you're a company and you are a wholesale of textile goods and you have a B2B, then the CLA of wholesale textile could be applicable on the company. So what do you check to see if a CLA is applicable? Well, that is, first you go to the scope of the CLA. So the scope describes which companies or which activities of companies fall underneath that collective labor agreement. So if the activities of your company fall under the scope, that will be the first check. After that, you have to check if you also have to apply those terms and conditions to your employees. And you only have to do that either if you're, as a company, a member of an employer's organization, and I expect that none of you are, or if the CLA has been declared generally binding. And if it's been declared generally binding, there's nothing you can do except for apply that CLA. A generally binding CLA is usually for a duration of 2 years. So when it ends, you can then again apply other terms and conditions. But the moment a new CLA has been agreed upon and is generally binding again, you will need to apply it. So it's important to just keep this in the back of your mind. We always do a CLA check when new companies become a client, but sometimes during the course of the events, the activities expand, and it might be the case that at a later point, the company does fall under an applicable CLA. The employment agreement itself. It is a relationship that can be agreed upon verbally. So if you talk to someone and you tell them, okay, tomorrow you can start working and you will get this salary, and this person starts working the day after, an employment agreement is there. So it's very important to remember that if you really want to make sure that all the agreed upon terms and conditions are clear for both parties, is to actually have it in an employment agreement. So it's not an obligation, but it is a very advisable step to take. And on top of that, there are a couple of clauses, such as the probationary period clause and the non-competition clause, that are not even valid if they are not agreed upon in writing. And the first one, fixed term employment clause, you can have a fixed term employment clause verbally, but there could easily be discussion about it. So if someone starts on a verbal agreement and later you say, no, it was meant to be for 1 year, prove it. So please always take that clause into consideration as well. And never have an employee actually start working without there being an employment agreement in place. That would be our advice. Then we have fixed term or indefinite contracts. Both are possible. You can give an employee, a first new employee to a company, both a fixed term contract or an indefinite contract. But also our advice here would be to start off with a fixed term. You never know if there's a good match between the company and the employee. And a fixed term contract just gives you much more flexibility to end the contract or let the contract automatically end if you're not very pleased with the performance. And termination is possible, however, it's a quite complex procedure, or could be quite complex, and an automatic end date is much easier in that regard. So there are some rules on how many fixed term contracts you can give an employee. At this moment, you can give an employee 3 fixed term contracts. And the 4th one will then be a contract for an indefinite period of time. For a contract to be consecutive, the time in between the contracts may not be less than 6 months. So it's not possible to give an employee 2 contracts for in total 22 months and then think, okay, well, I'm just going to have him not employed for 1 month because he also wants that, he wants to go on holiday, and I'll re-employ him, and then the chain is broken. That is not possible. There would need to be a total amount of 6 months in between. The gap needs to be 6 months before you can start again at the beginning of the chain. And the total duration, that's the last bullet point, is very important as well. Because you cannot give 3 contracts for 3 years each, having 9 years of contracts. The total duration may not extend to 36 months. Another point which is important is that the contracts that you offer are usually offered here with a Dutch entity, but also take into consideration if someone has been employed by the parent company before, because the parent company could be seen as a consecutive employer as well, and the duration employed there could be seen as part of the chain and needs to be taken into consideration. We always advise to give a fixed term contract, but it's not always possible. Sometimes if you hire someone, that person will negotiate an indefinite contract because they are, for example, leaving a very good other position in another company, and they would only accept the offer if it's an indefinite contract. So in that case, it's up to just weigh the risks if it's worth it. And there is a probation period as well, so you can hopefully do something with that. Another thing to remember, in 2020 there will also be a benefit. The government is really trying to get as many long-term duration contracts in place, and the benefit they thought of, or they thought would work, I don't know if it's going to work, would be that the unemployment premiums the company has to pay are going to be lower if an employee is on an indefinite contract. So the longer you keep someone on a fixed-term contract, the higher that part of the employer costs will be. Very important is also that for this indefinite contract, you need proof in a written form. So a verbally agreed upon indefinite contract will not help in this regard. So you really need to be able to show proof of an indefinite contract. So that is something to think about in 2020 as well, that it might be interesting to offer in indefinite contracts sooner and not all the way at the end of the 36th month. So the next slide will be the probation period. So if you want to offer someone an indefinite contract straight away, that is certainly possible. In that situation, we would really recommend to have the longest probation period possible, which is 2 months, in the contract. Because you can see under the second one, probation period of 1 month is only possible if the contract is more than 6 months. 2 months would be from 24 months and longer, or indefinite. And this is 6 months, more than 6 months. So if you give a contract of 6 months, you cannot add a probation period. So it needs to be 6 months and 1 day. That is a little bit not showing very much confidence in your employee, but usually employers tend to give a contract of 7 months and have that 7th month or the first month considered to be the probation period. And a probation period, why would you want that? It is to check if you are a good match with the employee, and also for the employee to check if the company is a good match with them, because you never know. And you have this whole recruitment process, but the moment someone starts to work, it could be different. Probation period, as mentioned before, needs to be in writing in the employment contract. If it's not in writing, it's void. If it is in writing, but it's the wrong duration, it's void as well. So if you include a probation period of 2 months in a 7-month contract, it's not that you can say, well, let's have then a probation period of 1 month. Sorry, my fault. No, the whole probation period is not valid. So please really be careful and just look at this sheet when you draft your contract, or ask our advice. And both parties can invoke it. So if the employee is not happy in the position, they can also resign. And resignation or the termination from the company side is per immediate. So it can just be any day within that month or within those 2 months, and the contract will end immediately. Of course, the employee will have a right to salary up to that point, but from then on, parties are released from each other. Yes, the last point is in the second bullet. The resignation or the termination can be done verbally, but also here again, we really strongly advise to have it in writing, an email, just confirming that the contract has come to an end. Because especially if an employee resigns, it could be in the heat of the moment. They might have had a bad day. They might have, doesn't matter. They could say, I'm resigning, and the next day they're coming back. Hi, I'm back. So if you have something in writing saying, hereby we confirm your resignation, and we're going to send a settlement agreement or financial settlement at the end, then you have something in place to prove it. And the probation period can also be included in a renewal contract. So you have your first contract, but if the second contract, or the third contract even, is more than 6 months, another probation period can be included, but only in the event that the employee is going to have a different position within the company. Because you know the person, you know if the person matches the company, but what you don't know if this person is going to do well in this new position. So it does give you a chance to include another probation period, but it really needs to be a distinctively different position, of course. Otherwise, it would be a means of terminating someone's contract too soon. Then the next topic we're going to discuss is the vacation days and the vacation allowance. Vacation days is probably something you are all used to, but the vacation allowance is quite typically Dutch. And we're going to discuss the vacation days first. And there are two types of vacation days, or actually three types. You have the legal vacation days, the extra legal vacation days, and the national holidays. So the legal days is the bare minimum an employee has a right to. And this is, once again, this is legislation. So this is from Book 7 of the Code of Conduct. If a CLA is applicable, it could be that different rules apply. But we discuss the legislation here, so you know, because most companies do not fall under a collective labor agreement. But keep in mind, if you do, there can be a deviation. That's also with the probation period. It could even be longer in a CLA. But the legal minimum is 4 times the employee's working hours in a week. So the most common calculation, if an employee works for 40 hours a week, it will be 4 times 40, which is 160, and 160 is 20 days a year. So it's per calendar year. The minimum amount would be 20 days. These days, you should encourage employees to take all these days within 1 calendar year, because the vacation is there, to get yourself energized again and be there, working hard. So, the idea is that people take it within that year. But there is an exception, or there is a possibility to take over the days you have left to the next year, but they will lapse after half a year. So after July 1st, the days of the previous calendar year will lapse. So that is important to also inform your employees hereof, because if they don't know, they might come back to you and say, well, I didn't know. The only exception would be if an employee really does not have the chance to take these days. For example, if 3 colleagues have left the company and everyone needs to work really hard to keep the company on its feet, and they're just not allowed to go on holiday, you cannot say after July 1st, sorry, they lapsed. But you do have to have a good reason for that to do that. The extra legal entitlement, that is usually 3 to 5 days per calendar year extra, that is the industry norm. They are not mandatory to give, they are extra. But most companies here in the Netherlands, they do tend to give some extra days on top of the 20. And they are, as I said, extra legal days, and they can be carried over as well. But they only lapse after 5 years after the year they were accrued. So if you accrue them in 2019, you have 5 years after, at the beginning of 2020, before they lapse. And lastly, we have the national holidays, which are approximately 7 to 8 days per calendar year. Christmas, Session Day, Easter, those kind of days. You're all familiar with them. The industry norm here is to pay them out, to give employees paid time off, but it's not mandatory, so you don't have to. The vacation allowance, that is the second thing, because you have vacation, but you also need money to go on vacation. So that's why the Dutch government decided long ago that you need extra salary to compensate you to actually go on holiday. And that is the industry norm, or not the industry norm, the legal amount is 8%. It can be higher, you can decide on a higher amount, but minimum is 8%. And a CLA could also deviate again from this percentage. It is over their gross annual salary, so you have to be careful if you, for example, work with a bonus. We always advise to mention if that bonus, if it's going to be paid out, if that is already inclusive of the holiday allowance or not. Because if you don't mention anything, it goes on top of their gross annual salary. A vacation days or vacation allowance will need to be paid over this amount again. There are options to already include in the employment contract that the salary you agree to is inclusive of this 8%, but it needs to be in writing. If it's not there, people will argue and argue positively that it's going to be on top of that. So that is also the tip below. Really be clear about that when you are talking to a potential candidate. If you are talking about salary, mention if it is inclusive or excluding this 8% allowance, because otherwise you might have a verbal deal on 5,000 euros a month, and then they come a week later, okay, that's exclusive of 8%, even though your budget did not go beyond that 5,000. So be clear about that. So a higher percentage can be agreed upon, have that in writing as well. And the moment of payout is usually once a year in the month of May. It needs to be ultimately in the month of June, so 1 month later, but most companies pay it out in May. It is also possible to pay it out every month, just 8% on top of their gross monthly salary, and have it paid out every month. And then they don't have an additional amount in May. That's up to the company, but also here, be clear about it, communicate it, have it in writing. If an employee's salary exceeds 3 times the minimum wage, it is possible to deviate from the 8% pay. This is very uncommon. Most companies don't do it, or they mention that already the amount agreed upon is inclusive of the 8%, and then you have it covered as well. Then we have the notice period. The notice period is important when you terminate an employee's employment agreement, because there are certain ways for termination. We will go into them a little bit more later on in the presentation. But if a contract ends automatically, a fixed term contract ends automatically, nothing needs to be, or something needs to be done. We will talk about that later as well. But it will end, so you don't have to give notice in the sense of this sheet. However, if a fixed term contract, if you want to end it prematurely, there needs to be a clause in the contract saying that premature termination is even possible. If you don't have that clause, it's going to be difficult. But if you have that clause, premature termination would be possible, and termination of indefinite contracts, of course. In both situations, you need to uphold the notice period. And the notice period for the employer depends on the duration, the length of the employee's service. So if someone has been employed by the company for less than 5 years, it's 1 month, 5 to 10 is 2, 10 to 15 is 3, and more than 15 years would be 4 months. And from the employee side, it is 1 month. So if an employee wants to resign, they need to uphold a notice period of 1 month. If you don't do that, if the employee does not do it when resigning, if the employer does not do it when terminating, the other party has a right to ask for compensation for not upholding the notice period correctly. However, there is a deviation possibility. That needs to be agreed upon in writing again, so we come back each time to having a written agreement in place. Sometimes it is just not sufficient time to find a new candidate, and 1 month notice period is a very short amount of time. If an employee does give notice on the 30th of November, you only have 1 month to search for a new candidate and person and have him employed. So it is possible to agree to a longer notice period for the employee, so let's say 2 months. However, that does mean that the notice period of the employer is automatically doubled. So 2 months for the employee means 4 months for the employer. If you do not word that correctly in the employment agreement, and I see that quite often, is that a notice period clause is in the contract saying 2 months for the employee, 2 months for the employer. That is not double, so it's incorrect, but that also means that an employee can either choose to say, I have 2 months, so you have 4 months, or the employee could say, well, it's wrong anyway, so I just will have 1 month, and that is the legal situation, and I'm going to resign with only 1 month. So make sure that if you deviate, that the deviation is correctly included in the contract. If a CLA is applicable, deviations are possible as well. And a notice period, as I mentioned before, is not necessary if the contract automatically ends at the end of the duration. In the probation period, you do not have to uphold a notice period. It is immediate. And if the employment contract is ended due to urgent cause. So that's firing on the spot or at will employment, sort of similar you don't need to uphold a notice period. I mentioned, but I don't want you to get confused about that. There's no notice period for to end the fixed term contract, but there is a notification obligation. So what does that mean? If you have a contract for a fixed term and it is 6 months, so not 6 months or longer, but 6 months, so it's a little bit different compared to the probation period, the employer is obligated to inform the employee of what is going to happen next. It is to give the employee, in this case, more time to search for a new job and not hear it one day before, we're not extending. So you have the obligation as a company to inform the employees 1 month upfront in writing if the contract is going to be extended or not. And not only if it's going to be extended or not, but also under which terms and conditions it's going to be extended. So there are 2 conditions. If you don't extend, it's just, we're not extending, this is going to be your last day. If you want to take your remaining vacation days, please let us know, and a financial settlement. If you do want to renew, you need to let them know under which terms and conditions. And there are some penalties if you don't do that. And now employment law sounds terrible if I hear myself talking about all the obligations you have as a company. But if you just follow them, it's very easy. So the employee can claim a penalty from the company the moment he or she is not notified. So no notification at all would mean that the company would need to pay 1 month's salary if the employee asks for it. The employee needs to go to court to claim it, so that is a pretty big step to take. But they could, and they have 2 months to do that after the end date of the contract. If the notification is given too late, for example, after 1 week, then the penalty is prorated. So then it's 1 week of a month time. They have a right for a penalty. Usually, this is the common practice, if no notification is given, but the contract is extended, no employee will probably say, well, thank you for the extension, now I want my penalty. You don't do that because you want to be a good employee. No, so that hardly ever happens, but that possibility does exist. Notification too late, it will be a pro rata portion of the 1 month's salary. This is the gross salary, so it's without the vacation allowance, it's without bonuses, it's without overtime, it's just the pure base monthly salary. And what happens if you don't do it, but you do keep the employee employed? So for example, December 31st, last day of work, and the employee shows up on January 2nd, just sits at his desk, starts working, and you don't say anything. Then the employment is tacitly extended. And that is extended for the same duration the previous contract was, with a maximum of 1 year, and under the same conditions. So be careful if you let someone work. Otherwise, if someone sits down, you have to say, no, sorry, go home, and then it might work. But you really have to be, take care of that. Notifying that it will be renewed, but not telling them under which terms and conditions. That means the employee cannot claim a penalty, but the employment will be continued under the same terms and conditions again. And most probably that is what you wanted, but perhaps you wanted to make some changes. That is not possible then. It will be renewed tacitly again for the same duration under the same terms and conditions. So be careful. It is when a contract is 6 months that this obligation arises. Termination of the employment contract. Well, this is a very big topic. Esme and I have given 3 seminars already on this topic for different clients. The same seminar, that's for sure, not 3 seminars, although I think we could have managed to get it into 3 seminars. No, it's a very extensive topic, and so we would love you to join if we host another one, if you are interested. But I will discuss a couple of points just so you have an idea of what it entails. So in the Netherlands, if a contract is not ended automatically at a fixed term. It needs to be ended via upfront permission from either the court or the UWV. And the UWV is an employee insurance agency, and they are also involved with unemployment benefits or with sickness, but they also are involved with giving permission to terminate a contract on the basis of business economic reasons. So that is the first two, business economic reasons, and if an employee has been sick for more than 2 years, you have the option to end the contract. Then you go to the UWV, you file an application, the employee has an option to defend himself, and then after that the UWV will decide if you have permission or not. With this permission, you still have to give notice to terminate the contract. So those notice periods we just discussed in the previous slides, you still need to uphold them. So with the permission, it's not like, I've got the permission, and you don't do anything, then nothing happens. So that permission is your gateway to send a letter and say, I have permission now, and with this permission, I have decided that I am, in fact, terminating your contract. And of course, every employer will do that because they went through that whole process to get it. So that is the first one. The other reasons, C through H, are reasonable grounds for termination through the court of law. So a company would need to go to the court and ask for termination, and the court will end it on a certain date. So you don't need to use the permission of the court to end it. The court will end it by itself. Sometimes upholding the notice period, sometimes they won't. It really depends on the situation. Sometimes the notice period is added to a severance pay. So it really depends on the case how it is ended, but the court ends it. And you need a reasonable ground. Frequent absence due to sickness, and that really is frequent absence. And being away for 2 days, coming for 1 day, being away again. So just someone has been sick for 4 times in a year. I find that a lot. That's not going to get you anywhere. The second ground, underperformance, that was what our seminar was about, is a very important one. If you find that the employee is underperforming, it is essential to keep a record of the underperformance. Really do have performance reviews every half a year, or twice a year even, and on a more regular basis if someone is really underperforming. Performance improvement plan, have something on file, and then go to court. If you don't have a sufficient substantiated file, you will not be able to convince the court that you have done everything possible to keep this employee employed. Well, there are some other ones. Irreparable damage, working relationship sometimes goes together with underperformance. Culpable acts or omissions, if it's not instant dismissal, but it is a very culpable act, you might be able to go via that route. So there are many reasonable grounds. And important at this point in 2019 is that you have to pick one and substantiate that ground fully. If you're not able to substantiate that ground in full, then you have a chance that the court will not agree to termination. So a combination of these grounds is not yet possible, but will be possible from 2020 onwards. So there will be a new ground I, saying combination of the above. I don't know the exact wording, but then you can combine. So that's going to hopefully make it a little bit easier, because it is quite difficult sometimes to really get one ground substantiated. And for all of them except for E, it is important that besides being able to substantiate the ground, is to also check within the company, but also in affiliates in the group, if there is a possibility to redeploy the employee elsewhere. You need to be able to show that you have checked that and there are no suitable positions within the company. There are some termination prohibitions. Sick employees are protected, pregnant employees are protected, employees who are on maternity leave or in the period after that are protected. So make sure to check if you even have a possibility to end their contracts. The ground rule is that it's not possible to unilaterally, as an employer, end it. So that is only possible in the probation period. You can end it unilaterally. But if you're not in that probation period and it's not an instant dismissal, so straight away, then you need permission from a third party, either the court or the UWV, to get permission to end it. The last resort, or the last option, and actually the option that is used most often, is in agreement with the employee. So a settlement agreement, mutual agreement. We do a lot of termination cases here as well. Most of them are settled by a settlement agreement. But even then, it is important to know how strong would you be, hypothetically, in court or at the UWV, because that is the way how to negotiate the terms and conditions. If you have a very strong file and you tell the employee, well, with this file, I've done so much. We have been talking about your performance for 8 months. We've had many reviews. I've documented everything. We had you went to that course to educate yourself on that topic, and still there's nothing is happening. Then you have a pretty good file, and you could go to court. Then you can easily say to the employee, I could go to court, but you've been employed here for a long time. It would be best if we can just discuss it and part ways with a settlement. If the employee or the legal counsel advising the employee knows there's a good file, they will probably do that because no employee wants to go to court. If you don't have a good file, the employee could just say, okay, go to court. I'm not settling unless, and then you're talking money. So then you talk about severance payments or a longer notice period or exempting someone from work, because you need the agreement, you need the employee to sign off on a settlement agreement. And they probably won't do that if you've done nothing. I mean, if someone has been employed for 10 years and then a new manager comes in and thinks, nah, it doesn't work, that doesn't work. You really do need a file substantiating as to why an employee can no longer stay with the company or be redeployed somewhere else. So settling is certainly an option mostly used. But when we advise, we always try to first find out how strong is your case, to also come up with a fair first offer and advise the company on how far they should be willing to go to part ways. Something that is going to change in 2020 as well is the transition payment. So when an employee contract is either terminated or not renewed, the employee has a right, is eligible to a transition payment. And the transition payment is meant to give the employee the opportunity to transition to a new company. I don't think anyone uses it for that, but okay. For schooling, for coaching, if there's a gap in between the employments, to have a little buffer. And this transition payments at the moment, now in 2019, an employee is only eligible to this transition payment once the employee has been employed at the company for 2 years, 24 months. As from January 1st, 2020, this will become an immediate option for the employee. So from day one of the employment, the employee will be eligible to it.
So we're moving on to slightly more the HR side of things. The first half was very much about the employment law. And we're going to talk about sickness, because unfortunately you can't avoid it. It does happen. You do get sick employees. And what we see is that the practices between the different countries are very, very different. In the Netherlands, which is a bit of a shock for a lot of people, so I'm glad you're sitting down. In the Netherlands, you pay salary for 2 years during sickness. It's quite a long time. I see a few shocked looks, yeah. There is a maximum on how much you have to pay by law. So by law, you have to pay at least 70% of the last salary up to a maximum. And the maximum is around, it's the 4,700 a month. It's around 55,000 a year at the moment, and it gets indexed each year. Saying that, a lot of companies in the Netherlands do pay 100% for the first year of sickness and 70% for the second. That is quite a normal practice. So you may think, I'll just go with the basic, do 70%, but then you might find yourself in difficulties trying to compete to get staff because they say, oh no, but with the other company I can get 100%. That gives me more security. So I don't want that. So it can be quite normal to pay 100%, at least up to the maximum. Whether you do above the maximum or not is up to you. We also see different variations. So for example, if I say to a lot of clients, they might say, oh, just do the basic to start with. We're just starting in the Netherlands. We don't want too much of a liability. We'll start with 70%. But that means that every time somebody is sick, you've got to adjust their salary, even if it's just for a day. If you don't do that, you kind of get people can sort of say, well, I thought I was always going to get that amount. You were paid 100% last time when I was off for a week, so why are you not paying 100% now? So to kind of cover that kind of short-term illness that people will go off maybe with flu or whatever for a couple of weeks, we often advise at least say for the first month 100%, then you don't have all the hassle, and then after that, if it's really long-term, then you can always pay the 70. There is an opportunity or possibility to take out an insurance to cover you for the cost of salary during sickness. However, I spoke to somebody about this earlier. If you already have a high sickness percentage within your organisation, the premiums are going to be quite high for that, because generally the insurance will kick in after a waiting time of maybe 1 month or 3 months, and they will refund the amount that you're paying to your employees. So it can be really interesting. Certainly if you're a small startup, you can't, really... you haven't got the funds to pay somebody while they're not there, because you're going to have to replace them with like temps or whatever in that period. Then at least you can keep up your obligations and you can continue to pay them. And then you can use that money to then find a replacement, for example, a temporary replacement, I hasten to add. So with sick leave, a lot of you I've probably already had contact with about sick leave, or my department have, because the sick leave management process is very, very well defined in the Netherlands. There's lots of laws and lots of practices that have to be followed. If you do not follow them properly, and you do not, in the eyes of the UWV, the Employee Insurance Agency, if you haven't done everything you could do to get someone back to work, you could be hit with a wage sanction, which is up to another year of payment. So 3 years in total. So you want to avoid that. And obviously, the longer the person is sick, the longer you're not getting them to work, and it's costing you money. So you want to get them back to work as soon as possible anyway. So I just wanted to highlight the payment side of things, but also just the practice. Okay, so what do you do when you have a sick employee? And what are you allowed to do in that process and whatnot? A few other obligations, I'm afraid. I know it's not happy news. Nobody likes obligations, but they are there. They are in the law. And the first one is that when you have a sick employee, you should register them with your occupational health and safety provider, also known as Arbodienst in the Netherlands. Maybe a show of hands, who already has a occupational health and safety provider? Okay, I see quite a few hands, so that's a good start. What we do notice is that people have them, but they don't register everybody with them, because they think, it's only 1 day, or, I'm not sure if they're really sick or if they're working from home. It's another one you hear very often, but you are obliged to register them within 7 days with the company doctor. That way, also from the company doctor, they will get in contact with the employee if he stays sick for a longer period. They will check what the reason is, because you're not allowed to know, but they are. And they can advise you about what the next step should be, whether they should be seen by the company doctor, or whether something else is going on. So yeah, good to register all cases. It's also important to register all cases because I quite often have clients come to me and they say, oh, I have this employee, they're sick. They've been sick for the last 4 weeks. I think I probably maybe need to do something now. And you say, well, yeah, that's fine. Yeah, we're on time. And then I ask, have they been sick in the month preceding this sickness registration? And then it turns out, well, yeah, they took a few days here and a few days there. And what that does is if it falls within 28 days of each other, they count the earlier date as the start date. So before you know it, actually you're counting back and maybe counting back again. Do you follow what I mean? So if somebody is sick now on the 1st of November, but actually on the 10th of October, he was also sick for a day. And before that, in September, he was also sick on the 30th of October. For this new sickness case from the 1st of November or whatever it was, the employee would be considered sick from that very first date. So as long as there's 28 days between, they all count as one. That means that your start date is much earlier, which means that your obligation to have them seen by a company doctor within 6 weeks counts from the very earliest sickness date and not from the most recent one, even though it was only a day. So it's important to have that history in the system. And to consider that, certainly if you have a long-term case, were they ill in the 28 days before this? If so, were they ill in the 28 days before that? And you keep going back until you get the earliest date. And that counts for your 2 years. That can be an advantage because the 2 years sickness then counts from that earlier date. But also your obligations start playing up before then. Yeah, you have to have the company doctor seen within 6 weeks. And after that, the company doctor would come with an advice. It's usually very vague because they're not allowed, because of medical secrecy, to tell you very much. So you have to read between the lines quite a bit. And they will tell you whether the employee is fit for work or not. Whatever they say, even if they say, no, this person really is sick, really is going to have to stay at home for maybe months, you still have to draft a plan of action with them. Now there's Dutch language forms available on the UWV site. UWV site. We have English language versions that we use for our clients because most of our clients don't speak Dutch, so it's not very helpful to have the form in Dutch. But you do have to appoint a case manager. And a case manager can be somebody from your HR department, it can be a manager, but it is the person who is dedicated to make sure that the process goes well. At Briddge, we act as case manager for our clients. So if you say to us, I have a sick employee, I say, fine, okay, I will make sure they get seen by a company doctor, I will make sure that that plan gets drafted, send it to you, advise you how to fill it in. And then every time the employee goes back to the company doctor afterwards, that's generally every 6 weeks. After that, if anything changes in the action plan, because suddenly they are able to do more, for example, then that needs to again be agreed with the employee on paper. And that's something that the case manager does. All of that file you just keep for yourself. At the moment, it doesn't go anywhere. It only is important, really, if the employee stays ill for 2 years, because then they will go to the UWV, and the UWV will say, did your employer and you do enough during your reintegration to come back to work? If the answer is no, and the answer will be no quite quickly if you haven't kept to all these deadlines and haven't signed all the forms on time, then you could get the wage sanction of an extra year, so a third year of payment, which obviously you don't want and we don't want for you. So it's very important to have that file well documented, regular contact moments with the employee. We would do that as case manager, or you should do it as case manager. But even if you have outsourced your case management to us, as an employer, please still keep regular contact with your employees. It's really important for them just to have a feeling, that someone cares, that they can come back to work at some point. And ultimately, as an employer, you are responsible. So even if, theoretically, if we mess it up and don't have enough contact, ultimately, it was in your charge, so you will be held responsible and you will receive the wage sanction at the end of the second year. So we will help you with that. We will partner with you in that. We will speak to the the company doctor before consultation sometimes to steer them a little bit, like, I think this is going on and I got this impression from this person. Can you make sure you really ask about this aspect? And they will do that. But yeah, it helps if you know how the system works and know what the role is of a company doctor, what they can say, what they can't say. So that's why it's often, an added value service to have it just outsourced. And, generally, I think most of you people don't really want to be dealing with that. You want to be running your business, and it's kind of an extra hassle. So it goes on and on and on. We have memos that can inform you of all the exact steps that you have to take at which time. At this 42nd week, you have to inform the UWV that you've got a sick employee. First year, you have to have an evaluation. The second year, you have to start looking at, okay, well, where are we? What is the situation? Do we think we're actually going to be able to reintegrate you within the next year in our own company, or do we actually need to start up what's called a second track reintegration outside of the company, so maybe in different type of work, and in which case you need to have started that already in the second year. If you haven't started it in the second year, again, you could get the wage sanction that says, well, no, you didn't do this, so now you've got to do it anyway, and you've got to pay salary while you're doing it. Ultimately, the government, the UWV, just doesn't want people to end up having benefits when it's the fault of the employer. So they will come back to you if ever they can. We've discussed some of these things, what not to do. Felina mentioned in her presentation that you cannot fire sick employees. So if you have an employee that is sick, you shouldn't start talking about termination, because then they can say, no, well, I'm sick, and you can't go there. And of course, the fact that they know that as soon as they come back to work, you're going to talk to them about this, it could be a reason for them to stay off sick longer. So you have to be very, very careful if somebody is sick, if you have just announced to somebody you're not extending their contract, or that you're planning on terminating an indefinite contract. A tactic can be, next day, I just register sick. It's all too much for me. I had bad news yesterday. Make sure you let us know about that, because then it's very important to get the person seen by a company doctor straight away to determine, is there real medical sickness here, or are they just kind of angry, and frustrated? And then we can also, or the case manager can then inform the company doctor of what's happened, so the company doctor can ask the right questions. Because otherwise they just go there and they say, are you sick? Yeah, I'm really stressed. Oh, okay then. Then that's not very useful. So it's good to know all of those kind of the situation around it, but not to push the issue of termination during sickness. Make sure you get legal advice first. Don't ignore the advice of the company doctor, I think is what I answered to Rosemarie's question. If they advise to do something, you have to have a very good reason not to do it. On occasion, I have had a company doctor that has advised that somebody could come back for 8 hours a day. And when I spoke to the person, they were like, oh no, I just don't know how I'm going to do it. And, from knowing that person, I knew the story. And I thought, I doubt this as well. I think this might be a wrong advice. In that case, you can get a second opinion. You can send them either back to the same company doctor, a different company doctor, or somebody completely external, or get a second opinion from the UWV. Likewise, if the company doctor says, you can build up 2 hours a day, but the employee says, I think I can do 8, that you've got, don't just do, although it's good that the employee is so keen, but it might actually set them back further. So if you have any doubt, try to stick to the company doctor's advice as much as possible. Once people start reintegrating, you have a little bit of leeway to say, okay, we agreed that you would build up an hour extra per day each week. We're going to miss a week with the build-up because it's actually a bit much for you. You have that leeway, but don't deviate too much without getting a second opinion or an opinion from the company doctor. Stopping salary or employee benefits. Some of our employers, again, different cultures, used to different things. They're like, well, they're sick, so I just stop everything. I stop their car allowance and I stop paying them salary and stopping everything. That's going to get you in a really, really difficult situation. So don't do that without thinking carefully about, can I actually do this, even if it's a cost reimbursement, commute costs. There's certain rules that are usually applied for when you can stop that. It's not always immediately. If the employee doesn't do their part and doesn't work on reintegrating, isn't willing to cooperate, then you can use that as a means to exert pressure. So you can stop or suspend salary, but again, be very careful and get legal advice before doing so, to be sure. Another one, long-term disability. Sometimes, small company, they've only got 3 or 4 people, somebody goes off sick, the work still needs to be done. So they think, well, I don't think that person's going to come back for at least 6 months, so I'm just going to take on somebody else on a year contract to do that work. Of course, then you get the situation that the person comes back to work and the employer says, I actually haven't got any work for you because this person's now doing it. You can't do that. You do have to have that flexibility and keep the opportunity, the original position open as long as the employee is expected to return in their own work. And that is decided by the company doctor. So again, you could kind of make your case very difficult by permanently replacing them. So we'd say, okay, fine, if you need to replace somebody, but then you might need to do a temporary replacement rather than a long-term replacement. And again, don't lose contact with the employee during long-term illness. That really can make it difficult for the employee to come back later, even though you feel like sometimes it's a bit of a, oh yeah, I'm going to ring them again and say, how is it? They say it's the same, and then you don't really know what to say, and it can be a little bit awkward sometimes. But even if it's just by app or whatever, just keep contact with them, show that you're interested. I hear from a lot of employees that they're like, nobody's really interested in me. The first couple of weeks, everybody was apping me, and now I think I've been forgotten, kind of thing. And that can be really demotivating for somebody that is ill. And as an employer, you are responsible for keeping that relationship warm. So you do need to keep that warm, even if you have a case manager. Yeah, the employee, as I said, they have obligations as well, not as many maybe. They need to cooperate with the whole process of getting the action plan together with reasonable instructions from the company doctor. They need to attend the appointments with the company doctor where possible. In our practice, quite often then you have a lot of foreign employees that might be like, yeah, but I'm ill, so I've gone back to my home country because there I have a doctor I trust, and you get a whole story, but they are still obliged really to come back to the Netherlands and be seen by the company doctor. That can't be a reason because they are employed here. But again, it's just a matter of pointing out really what you expect of them. Preferably in your staff handbook or employee handbook, if you have one, that says, you're expected to be available for appointments. You're not going to just turn around and say, oh no, I can't do that day. It's like, well, what do you mean you can't do that day? We're paying you, you're at home. Of course, they might have conflicting therapy sessions or something like that, and they can reschedule. But yeah, they have to cooperate. They really do have to cooperate, and they have a responsibility to seek suitable medical care. And the company doctor will always ascertain whether they think that the care is suitable or not. So sometimes they might say, I'm not sure they're doing all they could do. Actually, they need to go and see a psychologist, but they're refusing. Then they're not doing everything they can, and they could be held liable for that. So that's something you need to be aware of. What they should not do is undertake activities that prevent or slow down recovery. So like going up, if you're on your skiing holiday with your knee problem, is probably not really helping your recovery. Other things could be that you discover that somebody is actually doing lots of hobbies or things next to work, which are actually aggravating their complaints that they're off for. That could be an issue. It's not always an issue. I think for a lot of our for people from other cultures, they find it very difficult that somebody who's here 100% ill can say, oh yeah, but don't ring me on Friday evening at 5 o'clock because I'm going out for dinner with friends. And they feel like they shouldn't be allowed to go out for dinner with friends. It doesn't work like that in the Netherlands. That is actually considered to be quite a good thing to do, to keep contact with people, and it's actually going to help your recovery. But it's a culture difference. So be careful in judging that, though, maybe, and thinking that they're slowing down recovery when actually they're just kind of trying to have some kind of life or whatever. If the employee really doesn't do anything, I said you can stop salary, you can suspend salary, with the difference being that you don't pay it out for the moment, but as soon as they start complying, you do pay it backdated, and stopping would be to stop it completely. But really you need to be seen first to give warnings, or if the employee is not available, if they haven't responded to 3 calls from the company doctor, that you think, yeah, but hang on, where are you? Then you have to start sending letters and warning, preferably first a warning and then take more drastic measures that you build up. And get a legal advice before doing so to make sure that you're not coming down on too hard on them in the eyes of Dutch law, because that could again work against you. Then you end up with a disturbed working relationship which you have caused, and then it's going to be even more impossible to find a solution. Health and safety compliance, just in most countries there are some regulations about that, about what you're obliged to do. The first thing is the company doctor, for example, that you have to have an occupational health and safety service. There are a number of different things that you have to do. I'm going to go through them now quite quickly. And not having any one of these could lead to fines. The fines are not huge. We're talking 500 euros to 3,000 euros for each part, maybe. Where your biggest liability might be is if you haven't had a health and safety assessment done in your company, especially if it's a production environment or somewhere with machines, and there is an accident, then you could be held liable. And that's where it's going to really hit you and the costs are going to be high. So there are fines, but it's just in your own interest really to make sure you have fulfilled these obligations. So the first step is the occupational health and safety provider. Again, you can contact us about that if you like, or go with another party, but you do need to have a contract. Prevention officer. You need to appoint somebody from within your staff who will advise management and staff on health and safety issues. That doesn't have to be somebody who is ultimately responsible. It's not somebody who's ultimately responsible for health and safety, because that's still the company, that's still management. But they do need to advise, and this is usually the person who would then conduct the assessment. It could be any position. It doesn't have to be HR or office manager. It can be anybody. It can, even in smaller companies, be a manager, or the manager can take on that role. But it is necessary to document that this person is the appointed prevention officer, identify the tasks, identify how much time they have to fulfill them, and yeah, just get that in paper and communicate that to the rest of your staff so that if they see that there's a danger somewhere, that they know who to go to. That's basically it. Then you have the risk inventory and evaluation, which is kind of like the assessment. So that's that somebody would come to your office or your workplace. They would go through and they'd be like, oh, there's wires there that you can trip over, like we have here. That's not good. Your lighting is not sufficient for people. There needs to be more daylight. They look at work stress as well. So they would ask people in the company what the levels of stress like, how much do you get to take your breaks and all these kind of things. So they will make an assessment, and then you would get an action list that comes out of that. In most cases, the RI&E will need to be validated by an authorised company. Again, we have partners that can do that for you. They can also conduct the entire thing, so that they would come around with their clipboard in your building, or you can fill it in yourself first, and then they would look at it from distance and they would validate it for you. The recommendation depends on your industry. Again, if you're in industry or production, I would definitely say have somebody come by and really see what the workplace is like and what policies and procedures you have in place, and really identify where your risks are. We'll come back to them in a minute anyway. What quite often comes out of the risk assessment is that you need to have first aiders, you need to have people that can evacuate the building in case of an emergency. These people need to be trained annually. Even if you only have 1 or 2 people in the office, theoretically you are responsible to have something in place for this. And you are obliged as an employer to offer the PME, the Preventative Medical Examination. And that's basically that you're responsible as an employer to evaluate what the pressure is, what the health risk is for your employees in doing their work. So it looks at work stress, but it also looks at tables, chairs, RSI, lighting, the whole package. And you can do that in various forms. You can sometimes just suffice with offering the employee every 3 to 5 years, by the way, is the guideline, by just offering them a list, a questionnaire to fill in, and then they get an automated report back saying, okay, these are your health risks. Actually, you're too heavy, you're not doing enough sport, you shouldn't be smoking really, and your work stress apparently is an issue, so you should go and discuss that with your manager or go to the company doctor, for example. That's the most basic version, but you can also add on to that physical examination with a nurse. They would do blood pressure, they do your glucose, they do blood tests for your glucose. I think they do a urine test. So they do a number of tests, but there's several variants that you can choose from, depending on how many risks your work brings with it. We organise a PME with Arboned, the advantage being that it's already been organised, all the prices have been kind of determined, and we're ready to go. So if you want to take part in that, then let us know, and we can send you the marketing material, you publicise it to your staff, you say, hey, great, we're interested in you and we want you to be healthy at work and vital and all those good things. This is what we're offering, let us know if you want to take part. If they let you know, then you pay per employee. And it should be included in your policy how often you're going to do this going forward as well, and you need to make sure you actually do it then. So if you say you're going to do it every 5 years, make sure you do it every 5 years. If it goes through us, we will help you to remember. We have overviews of who's done it when. I do have one more subject, plus I promised to come back to parental leave. Just very, very quickly, GDPR, it's not just about HR, it's not just about employment, but obviously it has a huge impact. You are obliged to do certain things like have a data protection policy, but you also have a lot of other obligations under the GDPR. You basically need to be able to show that you are in control of your employees' data, you know where it is, when it is passed to other people and why. That you do not process anything that isn't necessary, that you're destroying it all on time. And there's a number of obligations in the GDPR that you need to adhere to. My next slide, this one, is a kind of a list of some of the most common ones. If you go through this and you think, I have no idea what that is, so I don't think we have it, then we have templates available and we can advise on that, particularly from the employment perspective. So if you come to me and say, you know, my clients, I process all my clients' data that go on the website, I can probably give you some high-level advice about that, but not in detail. But with employment, with regard to employment, we can help you with that. You need to have all of these documents. If you don't have things in order and you get audited, the fines can be huge. I'm sure everyone got that at the time it happened. Now we're kind of a year and a half further, everyone's calmed down and things are, it will be okay, but you can be fined up to 20 million or 4% of your worldwide turnover per year for a breach in this area. And one of the important things, for example, is registering breaches with the authorities. So you might think, oh, I've got a policy, that's lovely. But say that you do have a data breach, you don't report it, you can get really bad fines for that. So it's better to report them to the authorities than not. But again, we can advise you about that further.